Welcome and thank you for joining Seyfarth's webinar, Wage and Hour Traps for Massachusetts Municipalities. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Barry Miller. Barry, you may begin.
Thanks, Brooke, and you can go ahead and take us to the next slide. This is essentially the same thing that Brooke just read to us. I'll introduce the team here today. My name is Barry Miller. I'm a partner in the Boston office of Seyfarth Shaw, and I'm joined by my partner, Allison Silvera, and our associate, Tim Buckley. Each of us has spent a great deal of time and energy representing cities and towns in Massachusetts in various wage and hour related matters. And that includes litigation of large-scale class action disputes in court, arbitration of wage and hour disputes under collective bargaining agreement provisions, and a lot of advice and counseling work that is intended to help municipalities avoid the litigation that we spend so much time defending. And that's really the focus of this webinar. We've seen a lot in our representation of municipalities that has signaled to us over the years that there's quite a bit of potential exposure that, frankly, most municipalities are sitting on as a result of the confluence of various forces that we'll talk about over the course of this webinar. And rather than wait for the other shoe to drop and clean things up in litigation, what we want to do is give municipal employers the opportunity to address these problems before they become too acute and de-escalate any sort of disputes that may arise. So with that, the next slide covers our agenda for this presentation. And in some ways, this agenda kind of tells a story unto itself and represents the evolution of really stringent wage and hour requirements to municipal employers over the years. And one thing that's not on the agenda here is that we do expect to have some amount of time at the end of this presentation for questions and answers. If folks have any questions as we go along, we would encourage you to just go ahead and drop your questions in the chat, and to the extent that we can, we'll address those either along the way or at the end. Brooke, next slide, please. So this story essentially begins in the Great Depression, and the Fair Labor Standards Act was passed in 1938 along with a package of New Deal legislation that made for a pretty radical change in the regulation of the employment relationship in the United States. And that's one reality of what we deal with in representing not only municipalities, but all organizations in wage and hour disputes. We deal with a statute that is more than 75 years old and was literally written before the ballpoint pen was patented. So we have a statute that is very archaic, is not calibrated to the modern economy or the modern working environment in any way, and that still presents those somewhat antiquated requirements. For a period of time, almost 40 years, municipalities had a little bit of a grace period, and the law did not apply to governmental employers. For constitutional reasons, the Supreme Court initially held that the federal government could not regulate the employment practices of state governments and their subdivisions because that was a traditional state function and implicated federalism concerns. And so that was the state of play really until the mid-1980s. So you had this period of 50 years where there was all of this law developing under the Fair Labor Standards Act, including a complex body of regulations and a lot of case law that was developed in the context of private litigation with commercial employers primarily. And then suddenly you have this reversal of course. 50 years after the statute's enacted, now it begins to apply to municipal employers, and all of these cities and towns have to figure out a way to comply with this statute that even commercial employers really struggle with. And what you see here, we can go to the next slide, represents in some ways a one-way ratchet. You see regulation of the employment relationship and the way that workers are paid in particular that gets tighter and tighter. With a lot of things that have a political dimension to them, there's something of a pendulum that goes back and forth. And we see that, for example, in the traditional labor context, where the law tends to swing in one direction when you have progressives in control of the federal government, and it tends to swing back when you have conservatives in control of the federal government. That's not really the case with the Fair Labor Standards Act. Really, it tends to follow a pattern in which regulations pile on top of regulations and essentially snowball without ever really receding. And for municipal employers who kind of got brought to that party in the middle of the proceedings in the 1980s, that has posed some really difficult challenges because they came to this regulated environment with lots of provisions built into their collective bargaining agreements that were either incompatible with the Fair Labor Standards Act or just didn't account for it. And that's why we oftentimes refer to it as a square peg in a round hole. It's a set of regulations that just didn't really contemplate the types of pay that municipal employees had received, often for generations, before this law applied to them. And that fuels the one-way ratchet that we see in this regulated environment, because the nature of municipal collective bargaining is such that if workers have these entitlements, they're often very reluctant to give them up, even in exchange for other things. When a group of workers has a vested interest in a particular type of benefit, whether it's a longevity benefit or certain days off, whatever it is, it can be very difficult to get their unions to trade those entrenched perquisites for something else that may be of value to the union or its workers. And the other thing that we see that's related to this is a sort of market-based bargaining, where a group of municipal employees, say a union that represents police officers, looks not only to the history of that union's relationship with the given municipality, but looks to other towns around the town that they work for. And that becomes a currency of sorts. There's comparison across municipalities where constituents of a given city or town will say, hey, the folks in the next town over get this perquisite, we want that too. And there's just this cumulative tendency to continue to add these things to collective bargaining agreements. And typically, there's not a pause in that process along the way where the municipal employer asks itself, hey, what is this going to do to my overtime obligations as a statutory matter? And that's where a lot of the exposure that we deal with as wage and hour lawyers comes from, dealing with those old vestigial entrenched entitlements. Let's go to the next slide. Where those entitlements oftentimes become a problem, and what you're going to hear a lot about in the course of this presentation, is really overtime. For purposes of the Fair Labor Standards Act, there are a few major provisions of the statute. It has a minimum wage provision. It has provisions relating to the employment of minors. That's where the Federal Equal Pay Act lives. But most of the action for purposes of municipal wage and hour litigation comes about when a group of plaintiffs contend that the employer has not met its statutory overtime obligations, and they're usually keying that off of the Fair Labor Standards Act. And one thing that is a complicating factor here is that the collective bargaining agreements that pre-exist the FLSA's application to municipalities typically have an overtime regime of their own. And very often, it's not quite as simple as the regime in the Fair Labor Standards Act, which says pay overtime at the rate of 1.5 times the employee's regular rate for all hours worked in addition to 40 per week. It's a relatively straightforward standard. By contrast, municipal collective bargaining agreements can approach that in many different ways. And we see, for example, daily overtime. If a given municipal employee works more than 8 hours in a day, they might be entitled to an enhanced rate. Sometimes we even see stacking of that, where if you work more than 8 hours a day, for example, you might be entitled to time and a half. And if you were to work 12 hours a day, you might be entitled to double time, for example. And there are lots of those complications where you have an approach to overtime in your collective bargaining agreement that's just different than what the statute requires. And where municipalities tend to get in trouble is that you have to meet both sets of obligations. You cannot, for the most part, negotiate or contract away your obligations under the Fair Labor Standards Act, even if you're providing something of benefit in exchange for that. And in that regard, it can take on something of a no good deed goes unpunished sort of feel to it, because it's often these extra incentives and benefits that a municipal employer has provided to its employees that become the subject of an overtime dispute, where the employees are saying, you should have taken this additional benefit, rolled it into my overtime rate, and paid me on that. And your failure to do so creates all kinds of exposure. And it's that calculation of the overtime rate that really does tend to get people in trouble. I think with that, we can skip to the next slide. And I wanted to move to this slide because I could feel the audience out there saying, is this all going to be doom and gloom? Are these lawyers just going to tell me that my life is going to get worse forever and ever? No, we're not going to tell you that. 90% of the presentation is in fact dedicated to that theme, but we have a few slides here in the middle that present the good news that goes along with municipal wage and hour law. And one thing that the alternative approaches to overtime pay sometimes creates, inadvertently, but we'll take it, is a defense to certain FLSA overtime liability that can arise from legally gratuitous, or at least gratuitous with respect to the Fair Labor Standards Act, payments that a municipal employer has made. And so you see a bunch of statutory language on this slide, and what all of that boils down to is that the Fair Labor Standards Act contemplates that where a municipal employer pays a premium rate to an employee for working extra hours that either exceed a certain number in a day or exceed a certain number of scheduled days in a week or a month, or are on certain holidays, where the municipal employer is providing enhanced compensation for that work, it gets to take credit against FLSA overtime obligations based on that gratuitous benefit. So that can reduce the cost of FLSA-based overtime, and it can decrease exposure in litigation, where folks are contending that the city or the town has paid overtime improperly in the past. But there are two important limiting factors on our ability to trade off CBA-based overtime for statutory overtime. First of all, the premium rate has to be at least 1.5 times the employee's base rate to get credit. So for example, if you were to provide employees with 1.4x their regular rate of pay for hours worked in addition to 8 per day, you're going to get nothing out of that. In fact, it will make your life worse because the additional compensation that you've provided, the 0.4x and the 1.4x rate, is going to go into the overtime multiplier and actually increase your overtime obligation. So making sure that any credit we're taking is based on a rate that's at least 1.5 times the employee's base rate is critically important. It's also important that we make sure that any offsets we're taking fit within the triggers that the Fair Labor Standards Act has provided. There are certain types of payments that we can imagine, and some that we've actually seen in collective bargaining agreements that are consistent with the spirit of an offset of collectively bargained overtime against statutory overtime, but just aren't legally viable. So for example, if you had a police officer who was being paid 1.5 times his or her regular rate for court time, that wouldn't, in all likelihood, be creditable against Fair Labor Standards Act overtime unless that rate was paid because this extra work occurs outside that employee's schedule. But if you're paying a premium rate for something that is not additional hours of work, another example might be stepping into your supervisor's shoes and working different, having different duties, may or may not give rise to a premium rate that you can offset against your FLSA obligations. So that's an important thing to keep an eye on. And we can go to the next slide. The benefit here is not just limited to offsetting CBA time against FLSA time. There are certain circumstances in which we can take legally gratuitous payments not required by the Fair Labor Standards Act, but provided by a collective bargaining agreement, and take those extra dollars that you've paid employees and use that as kind of a fudge factor to offset overtime that might arise under the Fair Labor Standards Act. So, for example, imagine the hypothetical town of Bosterfield, Massachusetts, that has adopted a collective bargaining agreement that describes the overtime rate of pay and says we're not going to include a longevity benefit that we provided to employees in our overtime rate of pay. That's a violation of the Fair Labor Standards Act in all likelihood, and even though it's specifically negotiated for, the employees subject to that provision are going to have a claim that that longevity benefit should be included in their overtime for FLSA purposes. But if the city of Bosterfield also has a provision by which it pays overtime at 8 hours a day based on 1.5 times the employee's rate, and that employee actually does work some of that CBA-based overtime, we can take those premiums and credit it against the liability to that employee. So we can take the shortfall in the overtime rate based on the failure to include the benefit and set that off against all of these additional premium payments that may have been made to an employee. And depending on the particular facts presented in a given scenario, that can reduce overtime liability in litigation substantially. One huge open question presented by this offset that we use in court from time to time is how it's applied temporally. And the question really is, do I only get credit for gratuitous payments made in the same work week as an FLSA underpayment so that any offset is contained on a work week by work week basis, which provides a limited benefit to the employer? Or can I look across the liability period and aggregate all of the payments that I have made gratuitously to an employee and offset any and all Fair Labor Standards Act overtime liability to that person? That's an open question, and it's one that can make a huge difference in litigation, again, depending on the particular facts, but it's something to think about if you encounter this defense. Understand that there may be limitations on just how far you can go with it. And with that, I will turn it over to Tim to talk about a benefit that is unique to municipal employers in the form of compensatory time.
Thanks, Barry. And so when the FLSA became applicable to municipalities in 1986, Congress had passed an amendment to allow for compensatory time as a feature of the FLSA. And compensatory time and the purpose behind this was to ease the municipal coffers by reducing cash spent for overtime. Now, simply put, rather than paying 1.5 times the regular rate of pay for overtime hours, cities and towns had the option of providing comp time instead. Now, while comp time can certainly provide some relief to municipal coffers, it poses some dangers as well. The FLSA provides a series of specific rules that must be followed in order for the municipality to reap the benefits of 2070. And the failure to follow these rules can call into question the validity of the entire comp time system and can open up a municipality to liability. And so we just want to run through at a high level what these specific rules are. Now, the first rule, it's an easy one. It's for every overtime hour worked, the employee must get 1.5 hours of compensatory time. And that's just follows along the lines as you would expect with the FLSA, which has this wonderful theme of 1.5x for overtime hours. Second rule is also pretty simple as well. It must be the comp time system must be pursuant to an agreement, usually a collective bargaining agreement, or understanding between the city and its workers or the city and the workers' unions. And that's not something that is going to be particularly controversial in most instances. Quite often, the comp time system is going to be memorialized in a CBA, and there are going to be rules laid out in the CBA about it, but all the rules don't necessarily have to be. Now, one thing to note about the agreement regarding comp time is that there can be limits on what time worked is eligible for comp time. So for instance, if there are particular types of work that an employee might otherwise receive overtime for under the FLSA, um, a city or town can say that comp time will apply in this circumstance, but not in other circumstances where FLSA overtime might work. So, for instance, if you have a Parks and Rec department has a number of people stay late on a Friday in order to finish up some bills before the end of the week, or finish up some other administrative processes, they might say that that particular work is comp time eligible, or they might say that it's not comp time eligible. But these are rules that will be laid out in either the agreement or the understanding. Now, the third rule, excuse me, is that there are accrual caps that the FLSA has. And there are two different accrual caps that apply to the FLSA. And it's dependent on who is performing the work and the type of work that's done. So the first cap is what we see here is 480 hours. And that applies for public safety activity and emergency response activity or seasonal activity. Now, public safety activity is what we traditionally think of as police and fire work. To put it simply, there's fairly nuanced regulations on these points, but at a high level, we're thinking of police and fire activity. Emergency response activity is going to be somewhat of an extension of that, but it's going to extend to emergency responders that might not be police and fire, such as EMTs or dispatchers, who are going to be performing that work. And seasonal activity is actually not limited to the type of people who is performing the work, but it's actually based upon whether or not, regardless of the work performed, there are predictable, significant demands in the work for a period of time that happens year over year. And an example that you might think of is if you have towards the end of a city or town towards the end of its fiscal year, has its accounting department working tons and tons of overtime every May and June in order to do what needs to be done in order to wrap up the fiscal year. That might be an example of seasonal activity. There's a predictable, significant increase in demand that occurs with regular year over year and with regularity. But there are many other examples that you could think of as well, and it's again not limited to that type of work. So those three categories get the benefit of a higher accrual cap. The rest for the rest of municipal employees and situations, we're really looking at a 240-hour cap. And the idea behind the cap, of course, is that you can accrue up to those accrual limits, but once you hit that limit, an employee cannot be compensated with comp time under the FLSA for that. Once you hit the 240 cap, if that's an applicable cap, you have to be paying that person cash overtime at 1.5x the regular rate of pay. And I think with that, we can go to the next slide. There are two more specific rules that we want to keep in mind for compensatory time. The first is that, the fourth really, is that it must be accrued but unused comp time must be paid out at termination. And the basic idea here is, the idea of comp time is that you're giving someone time off that they're going to use as they continue on in their employment. But if they leave the employ of the municipality and they have accrued comp time, that they should be, and the law requires that they are paid up for that time. And the question then becomes, what is the rate? And the FLSA, believe it or not, provides us that answer. And the rate that it's really, you have two options. Oh, sorry, it's not two options. You have to pay at the higher of two rates. The first is going to be the final regular rate of pay for the employee. So at the time of termination, what is their regular rate of pay? Or the average rate of pay for an employee during the last 3 years. Now, you imagine in most circumstances, it's going to be the final regular rate of pay for the employee if you're thinking of a traditional trajectory of increasing wages year over year. But there are certainly circumstances in which the average rate over the last 3 years would apply. Perhaps someone got demoted in the last year or two of employment. but that's something that you have to do that comparison to make sure that the rate is being paid, the payout rate is the proper rate. And the last rule that we have for compensatory time is that, and this deals with how an employee who has accrued comp time can use that comp time. There are kind of two rules within this last rule. The first rule here is that an employee must be able to use their comp time within a reasonable period after making the request. Then the second rule here is that unless requested use is unduly disruptive of the operations of the public agency. And over time, this is an issue that municipalities can get tripped up on. And there's a fair amount of case law from across the country that addresses this last issue. What really is unduly disruptive of the operations of the public agency? And FLSA regulations provide us some guidance here. And they say that mere inconvenience is not enough, and that there must have good faith belief that the ability to provide services at acceptable level would not happen. And there's a number of instances where municipalities have gotten in trouble and been brought to litigation because they took a position that, well, if we have to pay overtime to if an employee requests to use comp time, and in order to fill that employee's slot, the city or town would have to pay overtime to a replacement employee. There were a fair number of municipalities that had the rule that they wouldn't allow the employee to use comp time. And that rule in multiple cases has been struck down and held to be invalid under the FLSA. So employers really need to be careful about how they're granting requests and the criteria that they're using to grant requests for the use of comp time. And really just be aware that that having to pay overtime to a replacement employee is probably a necessary evil to support a comp time system. And with that, I think we can take it to the next slide. And another aspect of these 1985 and 1986 amendments to the FLSA were to provide support for police and fire departments, because the Congress recognized that these departments are truly unique. I mean, they provide a public safety function, and they operate in hours when, frankly, the rest of us are likely sleeping. So there are 24-hour operations in which there have always traditionally been much different work schedules that police officers and firefighters work on that don't really fit into, as noted before, well, they don't really fit into the FLSA's general scheme of a 40-hour work week. And so what Congress has provided are three provisions that we'll discuss here today. The first addresses unique work schedules for police and fire. The second is going to talk about details. And the third, we're going to talk about some other historical practices, in particular, swaps. And again, these rules in particular, unlike comp time, these rules are limited to police and fire departments, and a little bit more nuance in that we'll get into. So Brooke, can we go to the next slide? So we can talk about the 207K work period. Now, the 207K work period is a complete divergence from the FLSA's standard idea of a 7-day, 40-hour work week. And so under Section 207K, it permits municipalities to implement a work period that is upwards of 28 days and 171 hours for police officers, or 28 days and 212 hours for firefighters. And that is, again, in place of the traditional 7-day, 40-hour work week. And the purpose of having this extended work period for police and fire is to permit municipalities to smooth out those spikes in hours that we see from the varying work schedules over a longer work period. So often firefighters, for instance, it's not uncommon for them to have a 24-hour shift, and they might work a 24-hour shift, be off for 3 days, and work another 24-hour shift. That is just vastly different than how most employees who are covered by the FLSA will operate. And Congress recognized that, oh, maybe municipalities are going to get really dinged under the FLSA if we have to try to fit these long-standing scheduling practices into the 40-hour work week. And they don't really want to be in the business of dictating how cities and towns should be scheduling their public safety personnel. And that's why a big reason why we have the 207K work period. Now, an important thing to note with the 207K work period is that doesn't apply to everyone in the department. It applies to individuals who are performing fire suppression or law enforcement activities. And so this means it's not going to apply to civilians that are working in the department. If you have a mechanic who is working at the police or fire yard to keep the fire trucks, police vehicles going, that mechanic is not going to qualify as fire suppression or law enforcement activities in most circumstances. And it is really the people who you think of performing, who are firefighters who are going out to fires, and police officers who are reporting out. And there's a slight more nuance there, but it's by and large that's going to be who's going to be covered. Now, we know this sounds great, but what do you have to do in order to establish the 207K work period? And here there's kind of an interesting divergence between the FLSA and state labor law. So let's start with the FLSA. With the FLSA, the bar is actually pretty low. There's a First Circuit decision, the Cavallo versus the Town of Framingham decision from, I think it was 2010 or 2009, that provided a lot of insight into what you need to do to establish a 207K work period. And in that case, it held that you don't actually have to provide notice or bargain with the union to satisfy your obligations under the FLSA. What that case also emphasized is that there are ways in which you can establish a 207K work period, and common ways that we've seen and seen across case law across the country are that oftentimes you have a letter from the city to the union just announcing that they're implementing a 207K work period, and that can often be very good evidence. And those letters can also date back to the time of 1985, 1986, when the FLSA was becoming applicable to municipalities. Other things you look for is you can look at your collective bargaining agreements and agreements with the union to see if a 207K work period has been previously bargained for. And this could be something that can come up during the course of bargaining and be memorialized. And then, I mean, the FLSA, and again, this is strictly under the FLSA, doesn't account for state law, that said that you can just kind of do it. There's precedent out there that you can just go ahead and implement it and just start paying officers in accordance with this. Now, there's a very important point here is that you could run into trouble under state labor law in taking that approach, because there was a 2009 SJC decision involving the city of Boston, where the SJC held that the implementation of a 207K work period was a mandatory subject to bargaining, and that you had to negotiate that with the union. And the basic idea behind that was that it's a change to the overtime pay and the compensation that officers are receiving, and it's a bargainable issue. So in Massachusetts, while the FLSA permits these favorable and relatively low bar for implementing a 207K work period, municipalities need to be careful to the extent they don't have a 207K work period or want to implement changes to it, that there are bargaining obligations that in all likelihood are going to attach, and those bargaining obligations might take away some of the real strong financial benefit of the 207K work period, but in all likelihood, there's still going to be financial benefit in doing it. And Brooke, can we go to the next slide? Now this slide, which is probably a little small as I look at it here, we don't need to worry about the details of it, I promise you. But what we have here is, this is just a chart that's actually in the FLSA regulations about 207K work periods. And what it is it goes from 28 at the top on the vertical axis down to 7, and that's the number of days in the work period. And then it has the maximum hour thresholds for fire protection and then for law enforcement. And there's just 3 things I want to point out about this chart real quick. The first is that the top line of 28 days, municipalities are going to gain the largest financial benefit of implementing the longest possible 28-day work period, because it raises up that hours threshold so high, up to 212 for fire and up to 171 for law enforcement. So there's a real incentive to try to implement the longest 207K work period, because it's smooth. It has a longer period in which you're smoothing out the hours. The next point is the bottom of the chart, where it's 7 days. You can implement a 207K work period that is only 7 days, but still raises the hours threshold. So there's even a benefit of doing it, because it raises, even if you're not going to extend it out, because instead of working 40 hours a week as the, once 40 hours a week is the threshold, you would have 53 hours for fire protection and 43 hours for law enforcement. So you get a benefit from there. And then the third point on this is that this is really just a sliding scale, and all of these options are viable under the FLSA. And there might be reasons why you want to have something that falls into the mid-range, but we just wanted to highlight that there are these options. If we move on to the next slide, please. Now, another significant issue that we have, another significant amendment to the Fair Labor Standards Act, deals with details. Now, details follow special rule. Details follow special rules under the 207, under 207P1. Now, as I'm sure folks know, off-duty details can be a significant source of income for police officers and sometimes firefighters as well. They can take many forms. You know, you can be directing traffic for roadside construction or working security at a high school basketball game. But these details are work that is performed outside of the normal course of an officer's, typically police officers, work, and they are paid often a separate rate for doing it. Now, the FLSA provides for an important carve out for what we consider, or what I'll call, third-party details. Now, third-party details do not have to be included in the FLSA calculation, or for FLSA purposes, if they meet two requirements. The first is that they're voluntary. Now, voluntary details is just that it's up to, we'll just use police officers as an example, it's up to police officers to actually choose to work a detail. And the second is that they're worked for separate and independent employers. And if those two requirements are met, then that means that the hours worked towards the threshold are not included towards the hours threshold, so they don't count towards your 40 hours or your 171 in a longer work period. And the amount paid for these details is not included in the FLSA calculation, and nor are the hours. So it really just kind of removes hours worked for FLSA purposes. Now, it's important to note that details that are worked directly for a city or town, they do need to be included in the FLSA calculation, because that's work that's done for the city or town. Now, there's a key importance here is how we distinguish between details that are worked for a city and town and details that are worked for third parties. And this can be the source of significant litigation. And it's important that municipalities think through how these lines are divided. And a clear example of a city or town detail might be an officer working roadside construction for a DPW road project. A clear example of a third-party detail might be if National Grid is digging up a road in your town and they have to hire a police officer to work that detail. That's a pretty clear example of one we consider a third-party detail. There's a gray area, however, in the middle, where we have officers who are hired to work third-party details, or are hired by a third party like National Grid to assist with the DPW road project. And there's a little bit of a split in the case law as to whether or not a detail would be considered a third party. I think the majority of cases find that would be a third party detail, but there's other cases out there that have held that no, those details are really for the benefit of the city, and thus they should be considered city details and be included for FLSA purposes. But it's important that municipalities think through how they divide between private details and city or town details and incorporate those into their FLSA calculations. And just the final note on this slide is that The FLSA regulations nicely contemplate that municipalities will do things to assist in the administration of these details. For instance, like have sign-up procedures or facilitate payment from the third parties to the officers, and then maybe even pay through the payroll processes. And the FLSA contemplates that those things will happen, those types of facilitations, and doesn't those facilitations do not indicate one way or the other as to whether or not it's a third party detail. If we move on to the next slide. Oh, there we go with shift swaps. The last thing we note here, and we won't spend much time on shift swaps, is that there are special rules under the FLSA under 207p3 to address shift swaps. And this is just the basic idea of two employees who are swapping their own shifts amongst themselves. And there's two basic requirements, and that's that an employer must approve the swap, and that the swap must be solely at the employee's own option. I think the important things here to note are really three things. The first is that the approval can be very tacit, and the primary point is that employers must have advance notice of it, and there's not much requirement as to what would constitute a approval. The second thing is that, by and large, these are voluntary shift swaps. There are agreements that are done between employees themselves, and not at the direction of a supervisor or the city. And then the third thing is that what's important here is that the idea behind shift swaps is that the FLSA does not require municipalities to concern themselves with private agreements between their employees to swap their shifts, and they permit cities and towns to use their own they permit cities and towns to treat the shift as if it was worked from the person who was originally scheduled for it. And there are a couple of other rules, or really guidance provided, US DOL opinion letters that we can just not get into now. And I think with that, we'll turn it over to Allison to tell us a little bit more about state law considerations.
Thanks, Tim. Hi, everyone. So in addition to the Fair Labor Standards Act that Barry and Tim have been talking about and just walked through, one thing we want to make sure is also on everyone's radar is how Massachusetts state law sort of adds another layer onto the requirements of the FLSA. And I know most of the attendees are in Massachusetts, so we'll focus on Massachusetts, but there may be other state laws depending on where your employees sit. The biggest one that we want to make sure everyone knows about is the Massachusetts Wage Act, and specifically the wage payment requirements of the Massachusetts Wage Act that talk about the timing of that pay. So they're a little bit different from the FLSA. The Wage Act requires that all wages be paid within 6 days after the close of the pay period. Massachusetts does have a law about overtime pay requirements as well, but unlike the FLSA and its amendments in the 80s that Barry talked about earlier, Massachusetts still holds that municipalities are exempt from the minimum fair wage statute. So we don't need to worry about separate overtime requirements, but this timing of pay requirement is important. And it's important for a couple reasons. But the first is that in April of, the first is that there's no good faith exception to the Wage Act and to the timing of pay requirements. So if you have a lot of times what we see is that municipalities have other timing, holdups in the timing of pay that might come from, for example, use of paper slips for reporting of details, waiting for supervisor approval that might cause wages to not be paid within 6 days after the close of the pay period. And when that happens, what the Wage Act requires, even if you pay it as soon as reasonably possible, you still owe triple damages and interest on those payments. And then if a lawyer gets involved on the other side, you would owe attorney's fees as well. And this is a strict liability statute. There is no wiggle room here. And if we can go to the next slide, Brooke. So it used to be, prior to 2022, it used to be that as long as the wages were paid in full prior to any litigation, it was sort of seen as no harm, no foul. So if a municipality or any private employer had made a mistake with respect to payment of wages and caught it, the way that the law was set up, or as we understood it, was that As long as you don't, it's not litigation that requires, that sort of prompts you to pay, you can pay it in full and then there's no damages to be had later. You just pay the wages as soon as you realize it. But in 2022, that changed. In April of 2022, a case came down from our SJC called Reuter versus City of Methuen. And in Reuter, what the SJC decided is that any violation of the Wage Act's timing of pay requirements, even by a day, and even if you pay those wages in full as soon as you know that there was an issue, statutorily requires that the payment be 3 times the amount of the wages paid late, plus interest, and then attorney's fees if an attorney gets involved. So Reuter is a concern to every employer in the Commonwealth, and something that we now see in the majority of cases of wage cases that are filed. All plaintiff lawyers seem to cite Reuter for in any potential wage case out there, and that's because there's no good faith exception to Reuter. So even if your payroll provider has a glitch and you issue checks a day late, or if there's a natural disaster, or something else arises that's beyond your control, wages that are not timely paid are subject to this mandatory trebling, and that is true every single time they are paid late under the statute. These heightened stakes can be particularly bad for municipalities because, at least from what we've seen, there are practices that have sort of long been in operation. They've never been challenged, things like the detail slips or paper slips or supervisor approval, things like that, that are just how things are done, that are technical violations of the Wage Act and that can cause all of these penalties to begin to accrue. This is also particularly compounded because our understanding is that often wage payment practices might vary across unions, across departments, there's separate payrolls. So managing all of that and making sure the wages are paid within 6 days after the close of the pay period can be difficult, if not impossible, to navigate. And what we've seen is that union attorneys representing bargaining units have taken notice of Reuter and begun to use it across the table in bargaining, or worst case scenario in litigation. And what they do is they assert that these sort of long-standing wage payment practices that everybody understood, that this is how it was going to work, violate Massachusetts law and put a lot of money and potential 3 years of back pay for late payment of wages at issue, whether it's as a bargaining tool or just because the members of the union who go into this start to get greedy, and the strict liability is something that's it's so clear that plaintiffs' lawyers are willing to make those arguments. Can we go to the next slide? So actually, let's go one more slide forward, Brooke. I think this is a little out of order. Yeah, so in the spirit of what Barry mentioned earlier, of maybe not everything in this presentation is doom and gloom, there may be one sort of loophole that's available to most unionized employers, and that is that under the Wage Act, there is one sort of timing of pay exception, which is that every city shall pay every employee engaged in the business, in its business, the wages or salaries earned by him, unless there is something that, unless a mechanic, workman, laborer, or employee requests in writing to be paid in a different manner. And in 2018, the Massachusetts Appeals Court acknowledged the viability of this exception in a case called Paris versus Sheriff of Suffolk County, and held that unions have the authority through collective bargaining to exercise the employer's election to request the payment of overtime wages be made under a different schedule. So what that means is that a collective bargaining agreement, as long as it's agreed to by both sides, that Paris holds that you can, in fact, negotiate something different in terms of timing of payment, as long as it is agreed to in writing and incorporated into the CBA. And in Paris specifically, what was at issue is that overtime, there was an agreement that overtime would be paid within 25 working days following the month in which such service is performed. And the court said that that was fine. That was a negotiated payment, timing of payment provision that would fall under this exception to the Wage Act. That is something that is important to keep in mind, and we'll talk about this in a little bit, but as you start thinking about what your payroll practices are, if there are ways to incorporate those, to just get them in writing and codify in writing what the payment practices are in the next version of a CBA, to the extent it's not already there. It can go a long way to alleviating what we know is a challenging to meet the 6-day timing requirements of the Wage Act. In addition to this loophole, it may also be possible, Tim was just talking a little bit about private details, and it may be possible to argue that the timing of payments for private details are not actually dictated by the Wage Act at all. And so this is very narrow. It's limited only to the circumstances of private details, which is details that are performed for outside third parties. So think Verizon fixing a telephone pole, a private event where police are needed. And the money that the employee receives for that work is not paid by the municipality, but instead by an outside third party, even if it flows through the municipality to get to that individual. In those limited circumstances, there's another law that comes into play, which is called the Municipal Finance Law, and that law governs the timing of payment, and it allows that payment not be due until 10 working days after the city receives payment from the outside vendor. In 2017, again, the Massachusetts Appeals Court considered this issue, and in this Malden Police Patrolmen's Association versus City of Malden case, held that the more recent and more specific language of the Municipal Finance Law signals an awareness of the legislature that when compensation for detail work is coming from a third party, a city's prompt payment of wages to officers who have performed such work may in fact be delayed past the Wage Act requirements, as long as it's paid within the timing that is set forth in the Municipal Finance Law. Again, this is limited. There are other requirements of the Municipal Finance Law that need to be complied with in order to avail yourself of the timing affordability that's allowed under the Municipal Finance Law. But it's good to know that it's out there. And if you think that you are going to want to for police details or any other detail type work that's paid by a private employer, you may want to have a conversation with a lawyer about the requirements of the Municipal Finance Law to make sure that you're fully taking advantage of it. Brooke, can we go back to the slide that was before this one? Perfect. So now you kind of all have the lay of the land for the FLSA and the Massachusetts laws that come into play when thinking about unionized employees. And my guess is that you're all wondering sort of what do we do now, and how do we start to assess the situation, figure out if we're complying or in compliance, or how do we best come into compliance to the extent that there are any errors that may be happening as a result of past practices. The first thing we recommend is get a lawyer. And the reason that I say that is that to the extent there are issues that come up historically, these strict payment requirements and the treble damages and all, what you want to do is have a lawyer and be able to avail yourself of the privilege to the extent there are issues that arise that you want to be able to talk and figure out how to manage without hopefully that getting out there and becoming public information available to your employees. You have a better shot, at least, of keeping the conversations confidential. The one thing that you can do, and like I said, we recommend sort of partnering with a lawyer to do this, is to proactively audit your payroll processes and the timeliness of payment before the next union contract negotiation happens. You can use that audit information to then realistically negotiate for the timing of payments that Paris allows, to realistically set different requirements around what the timing of pay may look like, or how you're paying based on some of the FLSA violations. You can do that hopefully by an audit. Armed with information, you could sort of make or suggest subtle changes in bargaining that wouldn't necessarily set alarm bells off on the other side of the table that there might have historically been an issue. This will look different for every municipality. It will could look different for your police, for your fire, it may look different depending on which sort of entity works on the payroll for that particular department. Your payroll people, as we were preparing for this presentation, one thing that came up is your payroll people are the most important people. You never knew how important they were. So partnering with your payroll team, making sure that the payroll team is on top of these requirements and getting checks out as soon as possible, and ideally within the pay timing requirements of either the law or the CBA as you've been able to negotiate. If you're dealing in Massachusetts and you discover a problem as you audit your payroll processes, in light of Reuter, you may not want to go ahead and fix that retroactively. You can fix it prospectively with subtle changes, like I was just saying, have conversations and try to conform, but you want to do it in a way that alerts, because the exposure could be large, you want to do it in a way that alerts the least number of people possible. I've mentioned a couple times, you know, the manual processes, paper slips, things that do typically delay timing of payment and make it less automated and more likely or rife for potential errors. Those may be the places that you want to start to look at sort of what's really going on there and what else you might be able to do. And with that, I'll turn it over to Barry to talk about some other sort of strategic thinking in terms of next steps.
Thanks, Allison. I think we've covered a lot of substantive territory today, and the one point that I want to emphasize and focus on is why we're coming to you with this information now. A lot of the requirements that we're talking about are very old, roughly Tim's age, as it turns out, but a lot of the legal developments that have really brought us in front of municipalities and resulted in us having to go into court to defend municipalities from multi-million-dollar lawsuits, which is something we do regularly, is a confluence of things that have happened in the last few years. One thing is that municipal employers in some ways are a soft target for plaintiffs' lawyers because of the limited resources that they often have. They're often operating with less than, state-of-the-art payroll systems and lots of older vestigial practices that are just natural to the municipal environment. And there may be a sense among a lot of folks who have been in the municipal world for a long time that this is just part of life and that there's nothing particularly acute or timely about all of this. But what we've seen in court is that there actually is a giant groundswell of these claims being filed. And we see the attorneys that represent municipal employees becoming very sophisticated in the claims that they bring. And we've seen that in the commercial space over the past 75 years. You get more and more nuanced, sophisticated, and subtle claims. And that's really starting to come out in the municipal space now, including with respect to provisions that the union has oftentimes proposed in the collective bargaining process. And that's really the trigger point for all of this. We've seen the attorneys who represent the municipal employees focus on these set of laws, understand the exposure and the difficulties that they pose for municipalities, and use them not only to get short-term gains for the employees that they represent in the form of damages in court, but also to leverage the larger collective bargaining relationship. And the only way that a municipality is ever going to come out on top, or less not on top, is to do the sort of advanced work that Allison describes. You have to know where the exposure is in order to eliminate it in a strategic way, oftentimes over a period of time. And so even if you don't have one of these cases landing on your door now, there's a very high likelihood that some of your existing practices are the sort of thing that can be a lightning rod for claims. And if you are able to address those issues before they become the subject of a legal dispute, the whole thing will be much smoother. We can guarantee only that much. And I think that covers it. We haven't seen a lot of questions come through, so if folks do have questions about anything we've covered, feel free to contact us with the email addresses you see there. And we thank you for joining us, and we'll be following up with copies of the PowerPoint and additional supplementary materials, and we hope it was helpful for y'all. Thank you.